Supreme Court Precedents and the Autochthonous Point of Law by Level Up Magazine Investigative Report. Introduction: Why Precedent Matters. Every court decision rests on precedent. For Indigenous Americans, the binding precedents of the U.S. Supreme Court have long defined jurisdiction, recognition, and the limits of federal and state power. Case number 125 CV 10,536 builds directly on this record, demanding that courts honor the laws previously established. 1 Johnson v. McIntosh, 1823. The court held that discovery gave European nations a right of preemption, but it also acknowledged indigenous nations as rightful occupants with a legal interest in their lands. This case is often weaponized against indigenous claims, yet it is also a recognition that title and inheritance are rooted in indigenous possession. Case number 125 CV 10,536 reframes Johnson v. McIntosh to affirm that Autochthonous Americans hold a continuing legal estate not subject to erasure. 2 Cherokee Nation v. Georgia, 1831. The court described indigenous nations as domestic dependent nations. While the phrasing diminished independence, the ruling acknowledged a guardian-ward relationship, establishing the federal trust responsibility. This creates enforceable duties that cannot be abandoned. Case number 125 CV 10,536 argues that misclassification breaches this fiduciary duty. 32. A landmark ruling, the court held that states have no authority over indigenous nations. Only the federal government can engage in relations with them. This precedent still stands. State interference is unlawful. Apply today. Case number 125 CV 10,536 reasserts that autochthonous jurisdiction is federal and constitutional, not subject to state manipulation. 4. The Marshall Trilogy, the foundation of federal Indian law. Together, Johnson v. McIntosh, Cherokee Nation, and Worcester form the Marshall Trilogy, the bedrock of federal Indian law. These rulings confirm: 1. Indigenous nations retain legal interest in their lands. 2. The federal government owes fiduciary duty and recognition. 3. States lack jurisdiction in indigenous matters. Case number 125 CV 10,536 leverages this trilogy as its foundation, not as relics, but as living precedent binding upon today's courts. 5. UNDRIP in modern alignment, international instruments like the United Nations Declaration on the Rights of Indigenous Peoples. UNDRIP align with these precedents, affirming rights to land, culture, and self-determination. Case number 125 CV 10,536 places these international standards alongside Supreme Court rulings, showing a continuity of law across centuries. Conclusion: reasserting the supreme law of the land, the precedents are clear. Title flows from indigenous possession. Federal trust responsibility is binding. State interference is void. Case number 125 CV 10,536 is not an innovation. It is a restoration of the original constitutional balance established by the highest court itself. By returning to these rulings, the case anchors indigenous claims in the strongest possible legal footing. Supreme Court precedent plus Article 6 authority. Level Up magazine will continue to examine how these precedents converge with current filings, ensuring that readers understand both the history and the binding law at play.